And Mr. Jones is charged in cause number 25 DCCR 0523 with the offense of murder. And Mr. May. And in cause number 24 DCCR 2431 with the offense of unauthorized use of a vehicle. Mr. Wilkerson has filed a motion just in the murder case, correct?
Correct.
That I reduce the bond.
Yes, Your Honor. Which I believe is set at 800, if I remember.
Let me pull it up so we make sure. Let's see.
Let's quote because I have had several of these.
It looks like in the motion it shows
Just the murder.
the murder is set at $800,000. And Mr. Wilkerson, do you intend to call your client or other witness?
Your Honor, I just intend to call my client and then also Venetia Jones if she is still present.
Mr. Johns, best you can, raise your right hand. Or Jones, I'm sorry. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can go ahead, Mr. Wilkerson.
Ms. Jones, you are obviously the same John Jones.
Under oath, Mr. Jones confirms he's been in jail for 4 months, awaiting trial for murder. He reveals that the actual shooter in the case has already confessed and received 30 years in prison. But this revelation raises new questions. If the shooter's fate is sealed, what role did Jones truly play? The defense tries to shift focus toward fairness, but the prosecution seems ready to show a darker side of Jones's behavior. Who should be held accountable when 2 people walk into a crime, but only one pulls the trigger?
Of that time, is that correct?
Yes, sir.
Now, the person who actually pulled the trigger with regard to this offense has pled guilty and been sentenced. Is that correct?
Yes, sir.
And that was to 30 years. Is that correct?
Yes, sir.
And he was on parole at that time, correct?
Yes, sir.
And until previously, at least as of the 24th of July, you have been off of 35, correct?
Yes, sir.
All right. Now, during the time that you have been incarcerated, you have had some run-ins with staff with regard to some behavioral issues. And obviously, if the court is going to consider lowering your bond and how you would be able to behave or would behave in the community at large, were she to grant a reduction in your bond, there are some concerns. And so I would like to give you the opportunity to speak to those concerns, and I would encourage you to emphasize conditions that the court might be able to impose that you would be ready and willing to follow that might curb some of those concerns for the court while this case remains pending.
Yes, sir.
Go ahead.
Let me say, while the write-up thing was going on and going around, I didn't have my proper medications, but I'm supposed to be seeing a psych nurse to take my proper medications. And I feel like if you was to give me a bond reduction, and I was to get those recommendations, and I was to make bond,
The tone shifts sharply. The judge begins to challenge Jones directly, reading through incident reports filled with threats, disrespect, and fights. When confronted, Jones denies each accusation from mocking officers to threatening to throw hot water. The judge's patience thins as she flips through pages of disciplinary records, saying, "These pages go back only 2 months." The image of remorse Jones tried to build begins to crumble. Can a man truly ask for leniency while denying every mistake in his record?
Don't make you say things like,
I'm even gonna sit here and frankly, I never said those things, but
you didn't say those things?
no.
You didn't ask her how could she have a boyfriend with how ugly she was?
Never said that.
You didn't ask how many boyfriends she ever had?
No,
You didn't say any of that. They're just making that up on you, just lying.
I have to.
Have to be lying. You didn't threaten just a couple weeks ago an officer that you were going to throw hot water if she didn't call somebody?
Yes, ma'am.
You did threaten to do that? Okay. Did you say at one point when y'all were getting in trouble that what it had to do with somebody giving a Bible back to another person, and you inserted yourself in something that wasn't about you, and you said, that's what's wrong with y'all officers. Y'all think we on y'all time, and I'm not. So you don't think you're on their time when you're in jail?
I never said that.
You didn't? They made that up too?
What I said was, respect is given both ways. That was my exact words.
Respect is given both ways. And so you think you deserve respect with how you're acting. I got pages of incident reports. And it's pages only starting in June. We're talking about pages over just the last 2 months. Fighting. You've been in at least 2 or 3 fights, right?
Yes, ma'am.
Yeah. Mr. Coleman?
Your Honor, I have just a couple questions. Mr. Jones, what did you do with the weapon after Lenny Nixon was shot?
I gave it back to Green.
And when did you and Green decide to rob Lenny Nixon?
Objection, Your Honor. These questions obviously go to the guilt innocence aspect of
I
this.
think you opened that door when you asked him about the shooting and who the shooter was. And the co-defendant.
When did the two of you decide to rob Lenny Nixon?
We never decided to rob him.
So if Green said you decided to rob him before he was shot, he would be lying?
I mean,
Yes or no? Yes or no, Mr. Jones?
yes.
Okay.
They were lying.
You knew the police were looking for you after Mr. Nixon had been shot, but nevertheless, you didn't turn yourself in, correct?
I didn't know. So
Okay.
after the fact, the next day.
When Lenny Nixon was murdered as part of this robbery scheme with you and Green, you were already under or on bail for UUMV, 2 cases of UUMV, and also a burglary of a habitation, correct?
No, sir. Never bailed out.
You were charged with those offenses, correct?
Yes, sir.
You
Regular
also-
accusations.
Right. You were also previously arrested for assault on a public servant, correct?
Yes, sir.
Criminal trespass,
Yes, sir.
another UUMV,
Yes, sir.
evading arrest, another evading arrest with a motor vehicle. That's all included in your criminal history, correct?
Yes, sir.
Who is Venetia Jones to you?
I'm
All right, pass the witness, Judge.
Thank you. Go ahead, Mr. Wilkerson.
Yes, Your Honor, we gotta circle back some of
The defense pushes back. Mr. Wilkerson brings clarity, reminding the court that even the shooter, Trevor Green, confessed to pulling the trigger and later corrected his own false statements. Jones insists he never wanted to rob anyone, saying, "Leave me out of it. I don't want no parts." The judge listens carefully, her expression unreadable. It's a pivotal moment. Is this a young man caught in the wrong crowd, or a willing accomplice trying to rewrite history?
and Trevor Green initially told officers that you had discharged the weapon that had killed Nixon, correct?
Yes, sir.
However, even he corrected that statement ultimately and admitted that it was he who had the weapon, correct?
Yes, sir.
And on that evening, he took your phone, correct?
Yes, sir.
And he provided you the firearm that had belonged to Nixon, correct?
Yes, sir.
Now, you were asked about an agreement to rob Nixon of a firearm, and whether or not an agreement was ever reached. At what point, or at any point, and if so, how did you learn of Mr. Green's intent of removing or taking a firearm that had been in Nixon's possession?
It was about that morning. Well, I'm gonna say around that night, 1, 2 o'clock.
What do you, and you say around that night, 1, 2 o'clock, what is it exactly that you were told at that time?
Nixon keep pointing the gun in our face. Let's just take it.
And how did you respond?
Leave me out of it. I don't want no parts.
And so, just very briefly, you yourself, Trevor Green and Nixon, had the three of you grown up together?
Yes, sir. We all went to the same school at one point in time.
Now, Trevor Green had just been released from prison, is that correct?
Yes, sir.
And is it the case that Trevor Green was actually coming into town to spend time with yourself and with Nixon? And Trevor Green, when he came into town, he was with his girlfriend, is that accurate? Okay.
Okay, we're not gonna try the whole case. I gave you some leeway, I gave him some leeway. I'm not gonna listen, I understand there's obviously some differences in opinion as to what happened and who's culpable. So that's all gonna be for a jury or for you guys to work out.
For just a couple more in a totally different direction, Your Honor?
Totally different direction.
All right. Now, you said you were getting your medications on the 21st. What medications are you speaking of?
The prosecution delivers a powerful rebuttal, citing the Texas Constitution. The prosecutor argues that since Jones committed a felony while already on bail, the court can legally hold him without bond. He lists Jones's growing criminal record, even as a juvenile, and urges the judge to deny any reduction. The courtroom feels heavy. Every word now weighs on Jones's future. This is no longer about mercy. It's about whether the system can trust him at all.
Have made a determination that you actually have audio or visual hallucinations?
Yes, sir.
Okay. Your Honor, as a result of that, we will need to request...
Just file the appropriate motion.
Yes, Your Honor. I'll pass the witness.
I have no further questions, Judge.
All right. And you said you had another witness. Can you proffer what that witness would be testifying to for me?
Your Honor, that would just be his mother, Venetia Jones, and to the little bit of support that she would be able and really the inability to raise funds.
Thank you. Okay, thank you, and I'm glad she's here. Thank you. Where is she? Thank you for being here, ma'am. Okay, anything else?
Just a really brief argument.
Go ahead, sir.
Yeah, I filed it, I put that argument, I made clear in the state's reply to the defense counsel's motion to reduce the bond, so I'm not gonna belabor it. I just hit the high points, Judge. If the court is so inclined, the state constitution, the Texas Constitution allows you to hold this defendant without bond because he committed a felony while on bail for a felony, Judge. I've cited the case law, I've attached it to my reply.
I don't see that reply on this case.
It would have been filed on August the 6th of this year.
I see a couple of things. I see an order. Oh, never mind. It's right here.
Yeah.
Sorry.
I cite Article 1, Section 11 of the Texas Constitution that states that if a defendant is on a felony, on bail for a felony and commits a subsequent felony, the court is well within its discretion to hold the defendant without bond if it so chooses to. And I've proffered to the court that I've spoken with the juvenile probation, with the juvenile department division of our office, and they have begun the process to certify this defendant as an adult, and that burglary habitation is on its way, should be making its way to your court soon, Judge. We've got the criminal history that I think speaks for itself. Your Honor, we'd ask that this court deny the defense counsel's motion to reduce the defendant's bond. In fact, if the court is so inclined, we'd ask that you hold him with no bond.
Thank you, Mr. Coleman. Mr. Wilkerson, argument?
Your Honor, I think that if you look at all of the incidents that were mentioned by Mr. Coleman, that are all juvenile incidents that have occurred with Mr. Jones, that it is quite clear in conjunction with some of the things that have also been mentioned, and also it fits into some of the write-ups that have been received as well, that Mr. Jones apparently does suffer some mental illness issues, and perhaps maybe we should hold this in abeyance until we can have that properly addressed in order to give the court some additional comfort that some of these behavioral issues might be more appropriately addressed.
Here's what I'm inclined to do at this time. I'm not going to hold the motion. We can always, if circumstances change, file a motion, and I will allow another hearing if there's a change of circumstances. Today, based on the nature of the offense, based on the amount of and nature of the incident reports from jail, based on the amount of and nature of the allegations of criminal history as a juvenile, Mr. Jones is 17, about to be 18, right?
Yes, ma'am.
So based on that, all of that, I am going to deny the motion to reduce the bond at this time. Obviously, it sounds like the jail's doing what they can to get Mr. Jones help. If you want to file a motion with regard to any other competency of whatever you want to file with regard to that, get that filed, and I'll take a look at it as soon as it comes through. All right, you go back with the bailiff. And listen, Mr. Jones, whatever issues you're having, none of that, in my opinion, coincides with how you're behaving, right? So you need to make an adjustment of what you're doing in jail. And if you don't, then Mr. Wilkerson's not going to have any argument whatsoever for me to reduce your bond later or anything like that. So I've probably talked to just about everybody in that dorm, I think, in the last couple weeks about this behavior. Y'all can all continue to act like you're acting, and y'all can all sit there and wait for your cases and then go to prison or whatever happens. Or somebody can step up and say, I'm not going to act like that. I'm going to get up when I'm supposed to. I'm going to follow the rules. I'm not going to fight. I'm not going to call names. I'm not going to, all those things. It's not that hard. Just follow the rules. You may not like them. Follow them. And if you can't, then stay in there and keep doing it. Does that make sense?
Yes, ma'am.
All right, go back with the bailiff.